Amen.
Senator Shireen Golden Campbell is traveling a little slower than usual, so she'll be late in about another 15 minutes or so. And obviously the chairman substantive chairman had indicated his absence from yesterday, that he would be absent today due to other pressing matters.
Thank you, Senator Sinclair. And I see an apology for Member Scott Motley. And I heard the member who is walking in on the radio this morning saying that he had to get to the Parliament. I thought he would have come at 11 sharp.
My colleague here from Senator vouch for my timeliness in the precincts of the Parliament. So I entered together.
But, you know, let me just say that I think the deliberations in the committee so far have been very engaging, and the questions have been probing, as they should be, seeking clarity on policy issues, on how the policy is captured in the bill. And for my part, I think it's a good sign. Good sign. All right, we concluded at Clause 82 yesterday to resume at Clause 83 under the head of suspension, revocation, and cancellation of firearm authorizations. Madam CPC.
83, suspension of firearm authorization. 1, the board may, by notice in accordance with subsection 2, suspend for such reasonable period as the board considers appropriate any firearm authorization granted by the board under this part if the board determines that the suspension is necessary, A, for public safety, or B, as a result of a complaint made in respect of the holder of the authorization.
Again, I don't like the latitude that is given in.
May I,
yes.
Senator Sinclair, may we just
go through
read
the
clause and then just pause for consideration of the issues?
2, the notice referred to in subsection 1 shall A, be in the form prescribed, B, be served on the holder of the authorization, C, specify the reason for the suspension, and D, state the corrective actions, if any, required to be taken by the holder and the time within which those actions must be taken and shall take effect upon the date of such service. 3, notwithstanding the provisions of this section, the board may withdraw a notice of suspension under this section where the board is satisfied that the circumstances which led to the suspension are no longer operating. 4, a person aggrieved by a decision to suspend a firearm authorization may apply in writing to the minister under section 86. 5, where the board suspends a firearm authorization under this section, the board shall serve on the holder thereof a notice in writing, A, stating that the firearm authorization has been suspended, and B, requiring the holder to surrender the firearm authorization as well as all firearms and ammunition to which the authorization relates to the board no later than 3 days after the date of service of the notice.
We can just pause to take comments on the clause. Senator Sinclair?
My first concern, and I will just list them out quickly, and I will await the responses. A reference to such reasonable period. I have a concern about that. And I don't know if it can be made more specific. It refers to public safety, all right? But then when you go to B, 83(1)B, as a result of a complaint, I think that needs some greater specificity. than just a complaint. A complaint about what? That the holder may have been driving quickly too fast on the road? But it doesn't give us any guidance at all as to what the complaint should be. In 83(2)(b), to be served on the holder of the authorization. Is there a clause that speaks to how the various service should be done in the there is one that speaks to service? Okay. Well, you can, in response, you can probably just direct me quickly to it. But, and in 83(4), about, well, applying to the minister. Well, I went ahead and read certain other things, so I will withdraw my comment on that aspect of it. So
Yes.
those are the comments that I just
All right.
needed some clarification.
Let's deal with the second matter first. Just seeking some clarification, Mr. Richards. What kind of complaint is considered in this clause that would trigger a revocation, a suspension of the license? What kind of complaint?
So I was hoping that Mr. Dalling would be here to offer a little more
This is
clarity.
not an existing clause.
It is not an existing
Right,
clause.
it's
Suspension is not in the current Firearms Act. It would have been a complaint, for example, and of course the authorities or the board of the authority is given the power to be able to make certain decisions. So as we have discussed, we don't expect for the board of the authority to be acting on frivolous complaints. It could be complaints that are related to the exercise of due diligence or yes, I won't say speak of the Dalling, but speak of the Dalling and he arrives. So of the Dalling. Right. So it could be complaints like that on the temperateness of the individual, of the license holder. And I think it was left deliberately broad, member, for the consideration of the board of the authority.
I do share the view, though, that it is too broad because a complaint can relate to any of many matters. And we don't want to run the risk of a board saying, well, this is the power I have, and I'm exercising it. It must relate to the use of the firearm and the endangerment of someone in that use. So some qualifying words.
Yeah, I'm agreeing with you, Minister, because when I read the first one, it's clear, public safety. And public safety can, in my mind, include the public at large or any individual, right? And then I wonder why all the rest would be there, because public safety, apart from something being wrong with the firearm and so forth.
I think perhaps a complaint in relation to the misuse of the firearm and endangerment of someone.
Still public safety.
Right. Well, public safety I can understand as a different limb because it can encompass something a lot broader, and we do know what that concept entails. But in respect of a complaint about the holder of the authorization, it does need some qualifying words.
Yeah.
Yeah.
Because again, as was mentioned yesterday, the law has to be blind to the incumbent at any point in time in terms of the latitude which is given. And I think, Senator Sinclair was, I'm thinking about frivolous use of the broad opening. So it will be very useful. And there's one other thing since I have the floor, Minister. From an operational standpoint, it refers to the board. In these instances, is it the board that makes that initial act, or is it the authority, the executive of the, not necessarily the CEO himself, but the authority makes those assessments and then take action or perhaps recommend. I could see the board probably sanctioning an action of the board, of the authority. But the initial phase is not the board who is going to act. It's not like an application.
Okay. Madam Chairman?
So
Madam
those
Chairman?
decisions are the
All right, so
are
we
taken by
need
the
to
board.
take care to ensure that the powers that are granted and, you know, are being exercised are exercised by the right entity.
Chair?
Madam Chair, if I may.
Yes, hold on. Member Williams, and who else is coming in?
Chair.
Mr. Darling. Ms. Grant?
I had a question just along the same lines too. In 5B, I'm checking whether the surrender should be to the board or to the authority.
Yes, yes. Member Williams, and then I will ask Mr. Darling to respond. I didn't hear you. Speak in the mic for the recording purpose. Use both, Member Williams. Or skip over to the front row.
No. My response was in relation to Member Jackson's query regarding the point, the person to, or the agency to receive the complaint. But as defined in the bill, the board is in relation to revocation and suspension relates to the board of authority. Isn't that so? Which means it's a board of authority as comprised. Because we only get to the review panel upon an appeal. So this is a board of authority that is defined.
I understand that, member, but I was just curious from an operational standpoint.
Okay.
And that's why Mr. Darling probably can assist.
Minister.
Recommends.
Let's hear a response from Mr. Darling of the FLA.
Operationally, it is the authority that receives the complaint from the public. And it is the authority that calls in the holder and initiates the process. One, in first, seizing the license as well as the firearm, and take a statement from the individual in relation to the allegations against. Once the investigations are completed, Madam Chairman, it is submitted to the board of the authority to take the decision to suspend the license. And that can be done, a preliminary suspension can be done pending the outcome of the investigation. Because at the end of the investigation, the board could make the final decision to revoke the license based on the circumstances. But it is done as a precaution, Madam Chairman, because of the danger to public safety in not acting expeditiously.
The authority comprises the board of directors, the CEO, and the staff that are appointed pursuant to the schedule. That's the authority. So you're saying who receives the complaint?
The authority. The authority, which is the staff. The staff and the...
Okay.
It's right. It's not the board that receives the complaint.
Right.
The board receives the recommendation from the authority.
Okay.
Madam Chair, so the authority is defined in the bill as the
In the
firearm
second schedule,
licensing
yes.
authority.
How it's
So
constituted.
established under Section 20. So my understanding is that the FLA receives the complaint, receives a letter, receives the intelligence, and then the process is triggered. And then it goes on now to the board of authority, where the decision is made to either revoke, suspend or revoke based on investigation. So it's like a tier system. The first step, the authority, the FLA proper, and then the elevated intervention of the Board of Authority, which comprises the decision maker, so to speak. Is that so? Member that CEO, darling?
You're absolutely correct, member, because it's a misconception that the CEO can revoke, deny, or cancel anyone's license. It's a misunderstanding in the public space. The CEO cannot make any such decision.
An important bit of information for those tuned in to appreciate. All right, the power to grant, suspend, revoke, cancel forms of authorization is vested in the board. And the board is a part of the authority, but Board of Governance. All right, so...
Sorry, Madam Chair. So, as Mr. Darling had, in response to Member Jackson, had it outlined the operational approach. When this statement that you said your investigators may collect from the holder of the authorization, is the holder entitled to receive a copy of the statement?
Absolutely. Absolutely. In fact, his statement, and the statement is read over to him, and if he agrees with the statement, that he signs to it. So he is indeed entitled to a copy if he wants.
It is on his request, or it is automatically a copy of the statement?
Just a moment. They get it automatically if request. If they request it.
Okay.
Yes, Member Davis.
Thank you, Chair. I just wondered, following on the question asked by Member Sinclair, whether he was asking whether the holder would get a copy of the complainant's statement.
No, let me explain. That one I will tell you, member, is very, very sensitive, because I will tell you we get complaint from within the household, right, of abuse, and not only a spouse, but the family itself, and based on the vulnerability of the family members in the whole household, it is dangerous at times, because we have found cases where family members withdraw complaint after, although when we investigate, we realize that the complaint is true, but the person later withdraws it for various reasons, and we do understand. We have had cases, and we have had malicious cases too, but we have had cases like those. So we are very mindful in terms of releasing the information. And let me say something here. Some of the intelligence, Madam Chairman, that we receive, sometimes in releasing it to the holder, we tip them off because they are not aware that they were being investigated.
I have to work something out, because in the exercise of any statutory function, there are standards that are required in the interest of natural justice. I appreciate that dealing with the firearms, which is a heavily regulated industry, there are concerns, safety concerns, public interest, public safety, personal safety concerns. But we still have to find a way to ensure that in the exercise of any of the functions, persons on the other end are treated fairly. And I think it's something that we have to start ingraining in all public authority. So there is a minimum standard that you cannot fall below. All right? If a complaint is made against someone, I think it is fair and reasonable for them to have some information in relation to the complaint, because they will have to respond either to say to the authority that the information you have received may not paint the full picture. And I do appreciate that the authority is under duty to ensure that persons who continue to be entrusted with an authorization remains fit and proper for the purposes. But we have to ensure that we are striking the right balance in the provisions.
Madam
Senators,
Chair,
yes.
I just want to say on that, the Court of Appeal addressed its mind to that very issue recently in a case against the FLA. And the Court of Appeal said that that standard that is held generally, it is not to be applied when it comes to matters of firearm and national security, because when we talk about a right, a person's right, and I'll refer you to the case, Madam Chair, and to the membership to read on that particular point that the court outlined, that there are certain unique security issues particular to firearms, and in particular, the uniqueness of Jamaica as it relates to that instrument, and therefore the test that is used generally in the case of a man and his right to employment and the standards held is a different one when it comes to a matter like this one. So I'll refer the judgment meant to the panel. I believe it would be helpful, Madam Chair.
Jackson.
Well, two comments. Let's start with the last one first. Mr. Darling, the court can make an interpretation based on the existing legislation. It's the prerogative of the Parliament to institute any laws that it sees fit that may amend what is currently existing in whatever shape or form, because you're not bound by that, otherwise you get into the whole realm of judicial legislation. So we have that exclusive prerogative, the Parliament. But the point I think Member Sinclair raised, which really interests me, is a complaint is made on John Brown that caused the authority, the FLA, to make an investigation, calling the person, etc. And they're acting on the basis of that report that they got. And I think you touched on it a moment ago, Minister. Natural justice, and I don't say natural justice in its legal definition, being a non-lawyer myself. Reasonable justice will say, if you make an allegation against me, I must not be denied without even being given a chance to put my side of the story for you to assess before acting. So almost instantaneously, when a complaint is made that would cause the authority to take a punitive action, because once you deny the person the right or the privilege to hold the firearm, right, they won't have that privilege and right anymore, that protection or whatever comes with it. Once you're going to deny them that, I think it's only fair and reasonable that they be given a chance to respond, I say almost simultaneously, and it's not practically simultaneous, but before you begin to deny them, you get an opportunity for them to give their side of the story. So you can at least administratively begin to sieve out, even in a minimal way, is it vindictiveness, is it some other unreasonable basis, but not to deny the person because they get a complaint, as terrible as it might seem. So I just want to make sure that enough protection is there to someone who we presume to be innocent of an allegation before we begin to punish them.
Yes, and Madam Chair, just for the record, to state to Member Jackson that in all cases we collect a statement from the individual, all cases.
I think sometimes I'm a little amazed when people speak of their experience and you get a response. And it's as if they're, I appreciate that each case turns on its own circumstances. And sometimes when people make complaint, you never know what the real situation is. And you can't assume without more that you are getting an accurate account of what has transpired. At the same time, I also know that there are genuine concerns about how the authority exercises its functions. So, two issues up for consideration now. For such reasonable period. Now, reasonable time is a concept that is known to law, and it has been interpreted. It turns on the unique circumstances of each case. What we, however, have is that sometimes reasonable time turns into unreasonable time, and there is a lack of communication in between. But if you're talking about issues that may impact safety and continued fitness to hold a firearm, I'd like to hear a little more if you would want to specify any time. So you say you're suspending in the first place. This is not a revocation. There's a requirement to turn in the firearm once a suspension is made. So is it reasonable time not exceeding such period, so it forces the authority to then proceed to investigate to a finality the matters in question? Because the person who has been authorized would have already been deeply vetted. So the question is, well, if we're talking about a reset going forward, because all kinds of issues may have occurred in the past. No, I'm not talking about a particular individual. I'm just saying there are a lot of concerns that have been raised about how things have been done. So the question is, based on the concern raised by Member Sinclair and others have weighed in on, whether the board may by notice, in accordance with subsection 2, suspend for such reasonable period as the board consider appropriate, not exceeding 2 weeks, 3 weeks, 4 weeks, until something is done. I'm just asking. Mr. Bailey, you want to weigh in on the matter?
Yes, Madam Chair. The difficulty in prescribing a timeline in this specific situation is because the reason for the suspension is to, in most cases, conduct an investigation. And it's quite difficult from the outset to determine how long an investigation will take to arrive at the resolution of that matter. So that's part of our challenge in prescribing a definite time.
Madam Chair, I could
also just to note at subsection 3, consideration could be given to change may to shall to ensure that the board is required to, if it is satisfied that the circumstances which led to the suspension are no longer operating, to return the firearm or withdraw the notice. So that ensures that at the point at which the board is satisfied that the circumstances no longer apply, that there's a requirement to withdraw the notice and return the firearm.
Madam Chair, I just want to add to what Mr. Bailey has said. Madam Chair, as it relates to investigations, we have had cases where we have had reports of persons convicted overseas. On the person's application, they denied that they were ever convicted overseas. We have had to contact international partners to get criminal records from the Bureau of Prisons. And sometimes that's a part of the investigation in terms of completion of it. And we do sometimes get back the confirmation that they were in prison overseas. So sometimes in terms of the investigations, Madam Chairman, it is difficult to say a month because of the various steps that has to be taken. Sometimes we have to go to the courts to get a record from the court. We have to go to various other places and to find witnesses to get statements. So a reasonable time is always depending on the particular circumstance that faced us.
Sorry, Madam Chair. All right, go ahead.
Maybe. Yeah, further to both Mr. Bailey's point and Mr. Dallin's point about the time that it needs. Do you require suspension to commence an investigation?
It's not in every single case you get a complaint, there's a suspension. No.
Because I'm thinking, Chair, if a complaint comes in, if the authority proceeds to investigate on the basis of the complaint, the evidence or information that comes in the first phase of that investigation might be one can inform whether or not you begin to suspend for 15 days, 1 month, 3 months, whatever it is. But to merely suspend immediately upon getting a complaint is what I'm afraid of, given how long the complaint might take and it turns up nothing.
Mr. Jackson, with Chairman, the authority receives complaints every single day, right? It is not in every single case of a complaint that the authority acts. Persons call, like our prank call is made and called to complain about someone. That is not the basis. We have to receive particulars, specific particulars on which we could premise an investigation to even commence in that process. And the first thing we do is to contact the holder. So we don't call the holder and say, give me your firearm on the mere basis that we receive a phone call from someone to say that this has happened. Right? Because there would be no basis. Because remember, when the matter goes to the board has a retired judge on the panel. You can't submit that we just received a call and that is the basis on which the board will act to suspend any license of an individual. You have to provide a case file on which the board could be satisfied.
No, but, you know, Mr. Darling, I don't agree with your approach, and I'll say this. Well, it says the board may by notice suspend as the board considers appropriate. I didn't say anything about satisfied. It says if satisfied that it no longer exists, that you can, the suspension is lifted. Is there something? But what I'm getting at, can the suspension be? Can the suspension be, say, for a period of, whether it is 30 days, right? And if because the board is operating on the guidance of, or whatever comes to the authority. So if the legislation puts in a time period instead of just a reasonable period, and the authority, based on the circumstances, needs additional time, then they get an extension of the time. Instead of you just having it there that suspension is for a reasonable period. Can it be that the suspension is for 60 days? And if you need period of time beyond that, then you have to, the authority has to make a presentation to the board for the board to extend the time.
So,
Chair, just to point out, in relation to 83 2D, paragraph D, we have a provision there that allows or permits the board to indicate to the individual, the holder, what corrective action they need to take at the time within which they need to take that corrective action. If that corrective action is taken, that is a basis upon which the notice must be lifted or will be lifted.
all right, Member Bunting.
It may not be something that fits into that category. It may not be something that fits into that category. Mr. Bailey.
Thank you, Madam Chairman, for recognizing me. And let me say that even though I've just joined physically, I was following virtually on my way here. And I observed what appeared to me a contradiction, where yourself, well, Mr. Darling first, and reinforced by you, said that the staff of the authority or the CEO have no legislative authority to either suspend, revoke, cancel firearm authorizations. However, Mr. Darling explained that operationally what they do is they get a complaint, they call in the person, they seize their firearm and their authorization pending investigation. And first of all, I'd like to ask him on what legal authority is he doing that now? Could you refer me to the section in the existing act? And secondly, it reinforces his description of the way that the authority operates, reinforces my earlier concerns that firearm authorization holders are subject to very arbitrary and capricious behavior potentially by the staff and the CEO. Because if they have to make no reference to the board in terms of the initial suspension and retrieval of the firearm, and that investigation could take an indefinite period, you know what it exposes a firearm holder to? Let's say the person got it on the basis that they operated, say, a supermarket. They handle a lot of cash. Somebody intends to rob them, but would like to first disarm them. They make a complaint to the authority. The authority preemptively seizes that firearm and then leaves the supermarket operator exposed. I'm just pointing out that hypothetical scenario to show you the dangers of allowing this to be exercised arbitrarily and capriciously. It is not the authority whose job, if there is immediate danger, to go out and seize the firearm. That report should be made to the police. The police are the ones who are not just authorized, but have the capabilities nationally to go and address whatever threat to either public safety or any other of these reasons why, if the firearm needs to be preemptively seized. I don't see that as a job of the regulator. That's the job of the JCF. So I am very concerned, and I think we should explicitly prohibit the management taking that type of action. There are myriad of complaints, and quite frankly, it encourages corruption. It encourages corruption when we allow an operator at the authority to arbitrarily seize somebody's firearm. We don't know whether that investigation may ever reach the board. A money pass, and that complaint is then deemed to be frivolous, and the person's firearm is returned. That is a risk I want to draw the attention of this committee and the public to.
Let's look on whether a power to suspend is a proper power to be given to the authority that grants.
No, I'm not questioning to the authority.
Let's just
to the board of the authority. I'm questioning to any administrative person at the authority.
Sorry, I didn't get that distinction. You're not questioning
the board.
Right.
I believe the board should reasonably have that
right. So in this provision,
authority, but I don't believe any individual who is not part of the board.
Just walk with me now. So clause 83(1), the power of suspension is vested in the board. Because what it says there is that the board may, in accordance with, for a particular time, all right, do something. Suspend.
You're reading what is in the bill.
Yes, because that is what we are discussing.
I don't have a problem with this. I'm saying what Mr. Darling, since the start of this meeting, has described as how they operate in fact. Is not the theory, how they operate in fact. And he said, and we can go back to the recording, but I'm certain he said, how it operates is that they call in the person, they take a statement from them, they preemptively seize their firearm and their authorization certificate, while an investigation now takes place.
My understanding of what Mr. Dallin said in response to a question posed is that it was in the context of the natural justice issue that when the power is exercised, they do make contact with the holder, and they also take a statement from the holder in order to get the holder's account in relation to any complaint
that has been made. I'm saying the description may have arose in that context, but what I'm contrasting is the difference between
Bunting, because
what
it's
is in law and what is operational.
It's important that we understand. It's important that we understand what is being said. So we're discussing the power to suspend. As drafted, the power is vested in the board. Mr. Dallin sought to clarify that persons are of the view that the CEO does certain things, which is not so. And he thought it important, and I had no difficulty with that. And I don't know whether you ought to have difficulty with it if from his perspective, it's an important clarification. Because what is contained in the bill is not a power that is given to the CEO, but to the board. And your response is that you take no issue with what is drafted. You're taking issue with the explanation Mr. Dallin has given. But perhaps you're taking issue for other reasons. In the context of the discussion, I understood what he was saying. And I believe those who were listening and following the argument would understand. It doesn't mean that there aren't genuine concerns, real and perceived.
No, but
all right, so let's know.
But you've missed my question. My question is, given how the management or the administration of the authority currently operates, which is not consistent with what is here, I would like to know what the current act says, because then it will guide us.
Provision. This is a new provision in the law.
So there's no provision for suspension in the existing law?
Madam Chairman, the only provision currently in the legislation is draconian. It's revocation, straight revocation. There's no cancellation, there's no suspension. So in all cases, even where a person brings his license in to surrender the license because he doesn't want it anymore, the only provision there is for revocation. And revocation has, in the current legislation, the provision for appeal. So if a man is dead, we have to revoke the license, right? And he has a right to appeal under the provision. So I'm saying to you, the current legislation is defective in many cases, and the fix, including the suspension and the cancellation that are in the bill now, are recommendations coming out of the FLA based on the operation.
So my point is, Madam Chairman, is that even though there's no such authority in law, Mr. Dallin has invented a power of suspension.
I believe there are grievance. I believe there are some grievance that this may not be the appropriate forum.
Please don't interpret anything I'm saying.
Okay.
Just the plain words of what I'm saying. We have heard Mr. Dallin say two things this morning. One, that operationally they routinely suspend people's license based on complaints, or their authorizations based on complaints.
I didn't hear him say that, though, you know.
He said that. I can go back to the PBCJ recording. And secondly, whether it's deficient or not, maybe we should have it, but it's not there. So he has arrogated onto himself and his administrative team that power. The second thing is he has made it clear there is no such power in the existing act. So the same, even though we're actually putting the power to the board, but what is to prevent the administrative procedures continuing as there are?
Madam Chair.
All right, just before you come in, just point me to the revocation section in the existing law.
36.
In the existing law. Member Golding Campbell, could you just read it for me, please, since I don't have it here?
Sorry. Section 36 of the existing Firearms Act. Subject to Section 36(1). Subject to Section 37, the authority may revoke any license, certificate, or permit if A, the authority is satisfied that the holder thereof is of intemperate habits or of unsound mind, or is otherwise unfitted to be entrusted with such a firearm or ammunition as may be mentioned in the license, certificate, or permit, or B, the holder thereof has been convicted in Jamaica or in any other country for an offense involving 1, the illegal importation or exportation of firearms or ammunition. 2, the illegal possession or use of a firearm or ammunition. 3, the use of violence for which a sentence of imprisonment of 3 months or more was imposed. C, the holder thereof has been convicted of an offense against the Dangerous Drugs Act or any other offense for which a sentence of 2 years or more was imposed. D, the holder thereof has been convicted of an offense involving 1, the unlawful discharge of a firearm in a public place. 2, failure to adequately secure a firearm or ammunition at his place of abode or work or on his person. 3, the unlawful use of a firearm to threaten violence against another person. Or 4, negligence resulting in the loss of a firearm or ammunition. E, the holder thereof fails to comply with a notice under Section 35. And 36(2), where the authority revokes any license, certificate, or permit under this section or under Section 18 or 46, the authority shall give notice in writing to the holder thereof. A, specifying that the authority has revoked such license, certificate, or permit, requiring such person to specifying that the authority has revoked such license, certificate, or permit. B, requiring such person to deliver up such license, certificate, or permit to the authority on or before the day, not being less than 3 days after delivery of such notice, specified in such notice. And 36(3), every person who fails without lawful excuse, the proof whereof shall lie on such person, to comply with a notice under subsection 2, requiring him to deliver up a license, certificate, or permit to the authority, shall be guilty of an offense and shall be liable on summary conviction before a resident magistrate to a fine not exceeding $200,000 or to imprisonment with or without hard labor for a term not exceeding 12 months. That is Section 36, Madam Chair.
All right. So you wanted to come in, Mr. Richards?
Sorry, Madam.
All right.
Madam
Let me just
Chair,
take Member Sinclair.
I want to just interject before the comments are made. On what is technically a point of order. The question and position that is being put forward by Member Bunting and asking us to, and Mr. Darling, to respond to what is in the existing Firearms Act. I am submitting to this committee and to you that it is beyond the bounds of this committee. When I look on the extract from the minutes of the Senate, as well as from the extract from the minutes of the meeting of the House of Representatives, it says that we are to sit jointly, members named, with a similar committee appointed by the House of Representatives and Senators, depending on which minutes you're looking at, to consider and report on a bill shortly entitled the Firearms Prohibition, Restriction and Regulation Act 2022, and not the existing Firearms Act. So going down the road that Member Bunting is, I think it is ultra-virus, this committee, and should not be permitted. What we are looking at is the provision in clause 83, and we must stick to that and determine whether what we have there is adequate, sufficient, we need adjustment to it, and not to be challenging the CEO in relation to the existing Firearms Act. So that is my submission.
That's a silly submission. The reason where
Madam Chair, I think the comment that is made by Member Bunting a while ago is really unparliamentary and should be withdrawn.
Member Sinclair, I know you want to shut me up.
I don't want to shut you up, Member.
The matters that I raise make you uncomfortable.
It doesn't.
But that's really not my concern.
Members Sinclair and Bunting, may I just ask you to Members Sinclair and Bunting, may I just ask you to pause? May I just ask you to pause? May I ask you to pause? It really is not in the interest of cordial and constructive deliberation to regard points of order as silly.
That was not a point of order. With respect, Madam Chairman.
But you know, Member Bunting, I understand that issues in relation to the operations of the FLA are issues that are related to the discussion of the bill. I understand and appreciate it.
That's the whole reason why we need a new bill.
Just hold on. But I'm going to ask that we spend the time and consider the provisions of the bill, because it is accepted, as you have just said, that we need a new law. So I appreciate that you may have concerns about the operations of the FLA. I appreciate that you come to these deliberations with the experience of a former portfolio minister. I understand that. Let us not use this forum to try to resolve all the grievances that may exist. But let us look on the provisions of the law to just ensure that we are putting forward something that will genuinely address concerns. So you have levied an accusation that the FLA, through Mr. Dallin, is exercising powers that it does not currently have, since the law does not provide for suspension, but that they routinely suspend. Let us just assume that that is factual. And the power that is given is a power of revocation when there are allegations of breach. To suspend instead of revoke may be a more palatable way to deal with it and less egregious to a holder. To suspend and investigate, including hearing from the person who's alleged to have breached the provisions, is a fairer way to deal with it. But right now, I'm going to return the committee's deliberation to the matter of the clause before us. And the clause provides for a power of suspension by the board in certain circumstances. And it sets out what needs to be done. Concerns have been raised about what would trigger an exercise of the power. One is in relation to the complaint. I think it is all agreed that, as stated, it is too wide, and some language must be introduced to give an indication of what kind of complaint that would trigger a suspension, the board exercising the power to suspend. Right? That's one point. Questions were raised about the time frame that the board could do the suspension, and an explanation has been given, which I think the law accepts sensibly. All right? The next thing we are looking at, Madam CPC pointed out that the surrender at 5, it may have been an error, Madam CPC?
With respect, you have not allowed me to respond, Madam Chairman.
I'm coming to you. I'm just giving you a summary of 5. 5, there is an error there, it appears?
Well, I'm asking if it's...
All right. So, go ahead, Member Bunting.
Madam Chairman, the memorandum of objects and reasons state that the justification for this new bill, among other things, is to address the operational challenges faced by the responsible authorities. Now, how can it then be ultra vires to discuss what these operational challenges currently are as this committee deliberates to see whether the clauses adequately address these operational challenges which the bill is designed to correct?
Did I not say that I appreciate that these matters are matters that would arise in the course of the discussion? Right.
But you allowed this so-called point of order, which ran exactly contrary to the memorandum of objects and reasons.
Madam
But
Chair, if I may.
Hold on. We still are considering the bill, and we're considering the bill insofar as the bill is seeking to deal with those challenges by making provisions. And one of the provisions now is to deal with issues that arise that relate to the fitness of someone to continue to hold it in certain circumstances.
Right,
and instead
so
of
I'm just
from one
pointing to the
extreme
relevance
to
of looking at the current operations. If the bill is to address the challenges, how can we know if we're addressing the challenges if we're not looking at the deficiencies in the current operations?
Madam Chair, if I might, because Member Bunting is really repeating and seeking to editorialize what Mr. Dalling has earlier said. We have all heard what Mr. Dalling said. The question, Member Bunting, is does this provision respond to that concern that you have? That's where we have moved to. We don't need you to repeat what Mr. Dalling said. We heard him. Please get on to tell us whether or not you agree that this provision is adequate to address that concern.
And I'm saying I don't think it is.
And tell us why.
Because there is no such provision in the existing law, but it doesn't constrain him from doing it. Should we say, therefore, in this clause, that the administrative management of the authority has no such power? Should we make that explicit?
Madam Chair.
Just a minute. I really think what you're asking me to do is really outside of my powers right now. Absolutely. And we're going to move to the ridiculous. And we better laugh at it because otherwise it would be too serious a matter. The other thing is that, I'm going to say something that I carried over from my previous role. Not my role as Attorney General, in my previous professional life. When a ruling is made in someone's favor, you don't really need to hear from them, It's when you're likely to rule against them that you give them an opportunity to be heard. And a standard in adjudication. So now, let's just return here because the sparring that is going to take place is not taking place under my chairmanship today. Member Bunting, get that clear, right? Right? It's not taking place here today. So I'm directing, let us, as Member Golden Campbell said, there are concerns. This clause is seeking to address the concern and bring a middle ground so you don't get to revocation. Let us see. You come with experience. Tell us what you think can be done to improve on it. That's where we are in the deliberation on this clause. But no sparring taking place.
The ruling is that we just move forward with the benefit of all that was said before. No, I am asking if this is ruling, so let's move on.
All right, let us just find out between Mr. Bailey, Messrs. Bailey and Richards, is there an error at subclause 5 in respect of the board, or should it be the authority?
Yes, there is, Chairman. For
right.
5B should be the authority.
Very well. That's what.
Madam Chair, can I ask a question which is sort of global, but it's coming to me in relation to this particular clause for suspension, etc. I don't know what the regional approach is to gun licensing, an area that I think I'm going to have to read upon. But are there any lessons in other legislation that might be helpful here? What is, in a jurisdiction with a similar practice? Is there a jurisdiction with a similar practice? It's a question. I do recognize that a lot of these provisions are new, but can we get any assistance from looking at other jurisdictions?
Yes, let me say, Jamaica finds itself in a very unique situation. It's actually one of the only countries where a civilian body is the regulator for private licenses. It's usually paramilitary, police, army or so, or Ministry of Defense that controls that aspect. In fact, Trinidad, faced with the problem that they face now, are actually looking at Jamaica to model that, our model to be used in Trinidad. And so that's the unique situation we find with ourselves in. Madam Chair, I just wanted to say to you, as it relates to the very section clause 83, the existing legislation provides for the FLA under section 26, Madam Chair, that on receipt of a complaint, the FLA may do all such other things as it considers necessary or expedient for the purpose of carrying out its function under the Act, having received a complaint. That matter was brought to the court, the Supreme Court.
Mr. Dallin.
No, I'm just...
I don't want you to respond to anything cross
No, I'm not saying that, Madam Chair. I'm just saying the suspension point. The point I'm making in terms of why it is now in the legislation, Sean, is that the court recognized that a suspension during that period of investigation may be necessary and considered expedient in the execution of the duties of the office. And that is why I'm saying that we incorporated the suspension cancellation clause here. Right, that's what I'm saying.
Davis.
Thank you, Chair. Just to go back to 83.1, I quite accept and agree with the explanation and the rationale given by Mr. Bailey as to why it says such reasonable period. But I wondered whether there could be an insertion of perhaps a 6-month period within which the board would have a duty just to advise that the matter is in fact being investigated. Because what has happened is that oftentimes, well, I don't know, I'm just suggesting, or 3 or 6, but it's a step from reasonable period where there's no time frame at all, just to indicate that the investigation is ongoing, because oftentimes some of these matters get lost.
No more than 3 months.
Or no more than 3 months, but just to say that John Brown, your matter is still being investigated, or at what stage it is, or if anything is being done, so that we don't have those instances where the matters are being investigated and without more, we go into year 2 and then year 3 without even knowing whether this investigation has begun.
Or going anywhere.
Very good point, Member Davis. Which really takes it back to the first question. I think the concern, it is understood that each case may turn on its own circumstance, but what you have to guard against is that action is taken and no communication is made and people don't know what's happening, and then they have to either pay a bribe to clear the way, skip the queue, all of that. These are realities, and we don't want that to be happening going forward. Shouldn't be happening now, but...
Chair, I believe that's something definitely to take into consideration. My fear and concern, however, is if it is that we prescribe something like that in the legislation, the authority is then bound to it. And if there's a failure if there's a failure in relation to that obligation, we then expose the authority. I'm recommending, and possibly what we could do, is that in relation to regulation of the authority, that there is some policy, ministerial direction given to the authority that in relation to any activity in relation to suspension, revocation, cancellation, that there is an obligation on the authority to notify, continuously notify the individual.
More than notifying, though. It is more than notifying. It's really, and it's a concern that is across government, is the time frame within which action is completed. You start something and you feel that, because you've achieved the first goal of plucking the firearm from the person who you have reason to believe may endanger someone, then that's it. It's a consideration, but since the committee seemed to be accepting the recommendation that some consideration be given, we cannot take a policy decision on the floor now, but we will note it and then consider it and come forward.
Consideration I would like for us to take is the timeline.
Hold on, and provisions can always be given for an extension of the time.
Correct.
Madam SG, you want to weigh in on this matter? You notice I've been trying to pull you in because I know you always have good perspectives to share. So we'll correct what is regarded as the error at 5, and we're going to move on. Next.
84, revocation of firearm authorization by board. 1, the board shall revoke a firearm authorization if A, the board is satisfied that the holder thereof is of intemperate habits or suffering from a mental disorder as defined in Section 2 of the Mental Health Act, or is otherwise unfit to be entrusted with such firearm or ammunition as may be mentioned in the license, certificate, or permit. B, the holder thereof has been convicted in Jamaica or in any other country for an offense involving 1, a prohibited weapon, 2, illegal trafficking in firearms or ammunition, 3, illegal possession or use of a firearm or ammunition, 4, the use of violence for which a fine or a term of imprisonment was imposed, or 5, negligence resulting in the loss or theft of a firearm or ammunition. C, there is reasonable cause to believe that the holder thereof, 1, was involved in the unlawful discharge of a prohibited weapon or any other firearm in a public place, 2, failed to adequately secure a firearm or ammunition, or 3, unlawfully used a prohibited weapon or any other firearm to threaten violence against another person, or D, the holder thereof is convicted of an offense involving domestic violence. 2, the board may revoke a firearm authorization if the holder thereof, A, is convicted of an offense other than an offense mentioned in subsection 1 in Jamaica or in another country, B, is charged with or detained in respect of an offense involving domestic violence, C, made a false declaration or provided misleading information in relation to an application to the board, D, breaches a term or condition of the license, certificate, or permit, E, fails to comply with the relevant notice under Section 79, delivery of firearms or ammunition for safekeeping, or 83, suspension of firearm authorization, or for such other cause as the board considers justified, considers justified the revocation in the circumstances. Oh, sorry, no, justifies is correct.
Madam Chair, can I just pause CPC for a second, please, to ask a question in relation to 84(1)(c).
Just before you ask the question, let's just take note that subclause 84(1) is where the board must revoke, where it's mandated to, and in 2 is where it's given a discretion on whether or not to revoke. So you're saying 1D?
84(1)(b), where 84(1)(c), where the board is bound to revoke where there's reasonable cause to believe that the holder falls under one of the 3 categories: unlawful discharge in public, failure to secure, unlawfully using prohibited weapon or firearm to threaten violence against another. And then D is curious to me. The holder is convicted of an offense involving domestic violence. So for revocation, the holder, if convicted of an offense involving domestic violence, then there must be revocation. But in C, the holder unlawfully used a prohibited weapon or any other to threaten violence. So there's no question of conviction there. What is it? It's a reasonable cause to believe. I'm just wondering why domestic violence rises to the level of conviction as opposed to reasonable cause. That's one. And if we're talking about domestic violence as a reason for conviction of a domestic violence, an offense involving domestic violence as a reason for revocation, what is the position in relation to the holder of a firearm who is convicted of assault and battery?
And before,
so domestic violence is treated differently.
No, it's related to the question. For those of us who are non-lawyers, we'd appreciate if the difference between reasonable cause to believe and reason to believe. I noticed when we had a couple of days ago, we were discussing the reason to believe.
I'm going to ask the SG to answer that
and
one.
then there's a reasonable cause to believe. I imagine there is some difference in standard because why we don't use the term consistently.
Madam SG?
Sorry, no, I'm not answering that question. I think that would probably be for the draft, though. But I'm just trying to understand the difference between 84.1b(4) and 84.1d. I'm assuming domestic violence is use of violence. No?
I'm sorry.
84.1b(4).
Uh-huh.
You're convicted because it was an offense involving the use of violence. 84.1d, convicted of an offense involving domestic violence. What's the difference?
Oh, so you're saying that 84.1d is already covered by 84.1b(4)?
Yes.
Okay.
Unless we can make a distinction that domestic violence is not using violence.
All right, I have a perspective, but let me allow the MNS team.
And even if we wanted to signpost it, I wouldn't think that this is the way to do it.
Right, I think it's a matter of signposting,
So
but I
this is
don't
not the
believe
way
it
to
has
do
been
it.
captured in the best way. Mr. Bailey?
Yes, Madam Chair. So in relation to the specific reference to domestic violence, it was in relation to an obligation under international law that our law provides for, firearm law, treaty, provides for treatment of domestic violence. It was accepted and appreciated, though, that 84.1b(4), by its very nature being so general, would have covered domestic violence, but for the signaling as well as for signposting, we thought it was necessary to have that discrete reference to domestic violence in the revocation provision.
All right, so we have to take some care in how we provide for it, because you might domestic violence is regarded as a ground. A conviction for a domestic violence offense is a ground for revocation. And remember, we're aligning our international obligations.
Yeah,
right?
but Chair, why wouldn't we then just include it at 4, the use of violence, including domestic violence?
You are going right where
because
I'm going.
I mean, as you know, if you're litigating and you have these two separate, the question arises: what is intended?
Correct.
Sorry, if
Member
we
Gordon.
formulate it that way, it's a bit ambiguous because it could be taken to mean that the violence contemplated must include domestic violence if you put it that way. So to me, it's less confusing to separate it than to lump them together.
So
Sorry,
what is a court to take from two separate references meaning the same thing?
Hold on, Member Golding, before
All right.
you go. Let me allow the SG to just come in on it.
Well, I was just going to say, though, I still don't know why we would need D. If it's an international obligation, what we would show in our report is that it's included in 84.1b(4). That's all. It's just for us to explain our law to our international partners, which we usually do when we do reports. So we don't always craft our laws the way they may write them in international treaties because of nuances. And it doesn't mean that just because it's set out specifically that way in a treaty, it doesn't mean that we have to follow it slavishly. We have to ensure we give effect to what is intended. We're going to give effect to what is intended in 1b(4). And I think that's all we would need to do is show our international partners that.
SG, just to...
Save and accept, SG. Your point is well taken, but there are some peculiarities around domestic violence and the signaling in respect of it. And we'll have to find a way to provide for it without causing more confusion than clarity.
Just to say, it says the holder thereof convicted of an offense involving. It doesn't therefore have to be conviction of a domestic of an offense under the Domestic Violence Act. And so, but for you, SG, perhaps whoever else can answer it, just to be guided appropriately. Under 84.1b(4), use of violence for which a fine or a term of imprisonment was imposed, including suspended sentences, including community service. So therefore, it could be, and perhaps the drafters could guide, that there is a widening of scope in subsection D, SG, that relates to offenses beyond that, unless it is that the suspended sentence and community service and so would be seen somehow as subsumed under fine, which I don't think it is, or under being a term. Well, it's not a term of imprisonment.
Belatedly welcome, Minister Charles.
I was hoping that you didn't have to. But thank you. But I think perhaps our drafters could guide us as to the thinking. Perhaps it's the widening of scope beyond that contained in B subsection 4.
Sorry, but if I could just interject before, if CPC wants to come in. My own perspective, I don't think that policy would make sense. I don't see why we would allow for someone who was given a suspended sentence for domestic violence to be caught, but they use the weapon in an assault and battery and it's not caught when they get a suspended sentence. I'm sorry, I don't think that policy is rational at all. So I'm thinking that if we were intending to expand it and include outside of fine and custodial sentence, it should apply across the board. It shouldn't just apply to domestic violence. It should apply to all manners of violence.
The policy is something that we would have to, of course, examine. But as it relates to the question I asked, what's your view? Would it capture?
No, so I thought I answered. It's clear that D would go further in the sense that it doesn't say fine or custodial, whereas 4 does. So there's a difference.
All right. It's a policy issue.
Sorry.
I think what is for sure is that a conviction for an offense in which violence is used is supposed to be a ground on which the revocation of the firearm takes place, right? Usually you don't specify the sentence in that way unless you're setting a threshold. So it could be imprisonment exceeding a particular term. So I think this 1B4 will have to be looked at, and the way that 1D is phrased can lead to interpretation that may not be intended. But we do know 2 things, is that the conviction for an offense including violence and also conviction of a domestic violence offense. All right, how we provide for them. Madam CPC?
Yes, Chair, thank you. I just wanted to point out that in the current law, there's a threshold of 3 months in terms of the offense involving violence.
Right, and I think that is how it's usually done. So we will flag these 2. The other question from Member Bunting had to do with reason to believe and reasonable cause to believe.
Yes, that's the distinction between 58.3D, where it says has reason to believe, versus 84C, which says reasonable cause to believe. I'd just like to understand the distinction between those 2.
Right, so there was no deliberate distinction intended, and in fact, for consistency, I would agree that the terms could be drafted similarly. So there's no appreciable difference between the 2. Reason to believe would require to have some cause, reasonable grounds.
But since we want our laws to be understood by the average Jamaican, if at all possible, wouldn't reasonable cause to believe make it more explicit to the layperson like myself that it can't be just any complaint?
Me to be a person, Member Bunting.
Sorry?
Never mind. Better put Member Jackson, and I'm sure coming from you, I will take it.
So as I understand, we want to make them consistent, and I would commend reasonable cause to believe as they.
You know, Member Bunting, your question really had me thinking. So, for example, from previous deliberations of the committee, in court, evidence is taken. It's not just the evidence on which you convict someone, and you're required to give reasons for your judgment, because the evidence has to be assessed. It has to then be applied. You have to determine whether there are inconsistencies internal to the evidence of a single witness, whether the evidence is discrepant between two witnesses on the same point, and then you have to assess the evidence against the standard that the law set. So evidence by itself is not how you usually take the decision. It's when you reason it out, and that's why reasons for judgments are given, and reasons to do something as opposed to you have information. Just thought I would, because you left me really thinking about it, and I had to delve into the parallel with the court system just to say that you may be just understanding it truly in a, well, I'm not so sure how you may be understanding it, but the reason is a little better. All right, let's move on.
Madam Chair, in 84-2, is convicted of an offense in Jamaica or in any other country as a me. Would that, I think we had a discussion earlier where we spoke about complaint. Would that be qualified by it being a use of a firearm or anything like that, or just conviction for an offense? And in 84-2B, is charged with or detained in respect of an offense involving domestic violence. Now, the two operative words there, you have charged or detained. But when we go back to clause 58.3, where it says that no firearm authorization shall be granted in respect to 58.3, which says that no firearm authorization shall be granted where you have domestic violence. So if you don't reach the threshold of a charge or detention, I suppose you could get it under the catch-all phrase at the bottom, or for such other cause, but would we want to put in what is contained in 58.3 that speaks to just acts of domestic violence, although you are not detained or charged? Because if under 58.3 you cannot get a license, but you're not. Where C speaks to
suggest that we just look at how the domestic violence concern is captured, both in terms of disqualification from being authorized to hold the firearm or suspension, revocation thereafter.
Yeah.
Let's just look back at it, because we know it is a ground, but how it is provided for, and that it is provided for appropriately across the powers.
Thank
Yes,
you.
Madam Chair.
Yes,
because I
Member
noticed,
Williams.
if it pleases you, Madam Chair, just to add to Member had a lapse there. Senator Sinclair. Senator Sinclair. If it is that in relation to Section 58, 3C, it's a 33C. If it is that being detained for a domestic violence allegation or is not a disqualifying element. So it's not stated here in the it says domestic violence, but it says who is charged with an offense involving domestic violence, which would cause the person to be unfit to be entrusted with such. But so what my point is that History. History. My issue is there a particular reason detained is absent under authorization under Section 58, but yet included under revocation? That's just my, is there a thinking, what's the rationale behind it? Because we do not say detained in authorization, although we admit that, yes, you can be captured under the history because being detained. Yes, 84.2 uses the word detained. So you can be revoked if you are just detained without more. So it is not in relation to applying from the onset for an authorization.
I think the concerns that have been raised about how the issue is captured is accepted, and we will have to just revise how it is provided for.
Very well.
Across the different provisions.
But could we say, in terms of guiding the drafters, can a principle establish that it should be a similar set of circumstances, that whatever would have prevented you from getting the license should be a parallel set that would cause a revocation? I mean, I'm not sure why we would have two different standards, because
just phrase it to consider whether the standard should be same or it should be different.
Right. I'm suggesting that it should be the same standard that would have prevented you from getting a firearm that should cause it to be revoked. I'm saying, why would we have two different standards? I don't understand the justification.
I want to answer it now, but I appreciate the concern, and I think it's something that we will have to look at. But I appreciate the concern, and the technical team will come back. We make the note, all right? So we can move to the other clause, having noted that we will have to come back to this one, all right?
Okay. 84.3. Where the board revokes a firearm authorization under this section, or where a firearm authorization is deemed to be revoked under Section 79, temporary storage or custody of firearms or ammunition, the board shall serve on the holder thereof a notice in writing, A, stating that the firearm authorization has been revoked, and B, requiring the holder to surrender the firearm authorization as well as all firearms and ammunition to which the authorization relates to the board no later than 3 days after the date of service of the notice. 4, a holder who fails to surrender an authorization, firearm, or ammunition in accordance with a requirement under subsection 3 commits an offense. 5, a person aggrieved by a decision of the board to revoke a firearm authorization may appeal to the minister under Section 86.
Say that the entire, this provision, I believe, is going to be either take note or revised. Yes, 84.5. So the policy in relation to the appeal has been reconsidered, and in particular the role of the minister. But I will wait until the substantive chair returns for that to be, yes. All right, so we can just put a square bracket around. 84.5. Who you appeal to if you're aggrieved by a decision of the board?
Well, that's about when you reach 86 years.
Right.
Sees
yes, we're coming to that.
But, Madam Chair, I'd asked Mr. Richards when we were dealing with about the service, when we were dealing with 83, I don't think he had actually addressed in regards to how the service of the notices. You were directing me to a provision that speaks generally to this service of notices from the FLA?
Right, so the provision is at 108.
At 108?
108.
Okay, thank you.
So excuse me, Chair, is it that there is no appeal or the issue is who the appeal is to? I'm not following the comment about the removal. Meaning it's not to remove the right to appeal, it's just...
No, no.
Oh. Okay, so
Yes.
then I have another comment, which is that we should insert, the committee should consider inserting a provision to say that the board should give reasons in writing.
Yes. Thank you, SG. Well, in respect of all adverse actions taken for which a right of appeal is granted, then reasons would have to be provided as a general principle. I'm sorry? Right. Once an adverse decision is taken and a right of review is granted, then the reasons, because the review would have to be as against the reasons. So we agree that, yes, the insertion, Ms. McCarthy, the advice of the learned Solicitor General in respect of the insertion of a giving reasons clause. All right?
85, cancellation of firearm authorization. 1, the relevant authority may, without prejudice to the holder thereof, cancel a firearm authorization granted by the relevant authority under this part: A, on the request of the holder; B, on the death of the holder; C, where the relevant authority requires any amendment or discovers any error in the issuing of a firearm authorization and it is necessary to correct the error; D, in the case of an authorization that may be granted under Section 58, if the holder thereof was granted the authorization contrary to the conditions prescribed under Section 58, or E, in such other circumstance as the relevant authority considers appropriate. 2, the relevant authority.
Can I just bring your attention to 85(1)D? In the case of an authorization that may be granted under 58, the firearm authorization section, if the holder was granted the authorization contrary to the conditions prescribed under Section 58, are we allowing the authority to review itself? Is that what we're doing? I mean, I'm trying to understand. The power to revoke or the power to suspend must be triggered by the number of things set out in 84. But are we in 85(1)D? When is it that these conditions, the contrariness to the conditions would have arisen? After the grant, or are you saying at the time of the grant was made contrary to the conditions?
Remember, these are...
Team MNS.
All right. No. Madam Chair, to the question to the member, the situation that confronts the FLA operationally is this. There are many persons who were granted firearm licenses under conditions or circumstances that were contrary to the law, meaning the law said that the persons should not be granted, and they were granted the licenses. And there are cases where the persons were denied the license by the very board and then granted it. Now, the opinion was sought of the Attorney General as to how to treat with these matters. The Attorney General reasoning was that if the board granted a license that ought not to be granted under law or contrary to their functions, meaning that they acted outside of the scope of their function, that license is null and void. But the existing legislation only gives the board the power to revoke a license under set circumstances. So there was no manner in which the board could respond to such a matter, even though so we couldn't cancel, they couldn't revoke, because there's no provision. The license would be deemed null and void. But how do you cancel a license that the person actually has or revoke it if there's no power to do so, although the Attorney General is saying the license is null and void nonetheless.
But
So-
hold on, Mr. Daly.
Yes.
Hold on a second. Because 85 is giving the relevant authority, which is what? The board or the authority? Why don't we say the board? Why are we saying
Why?
relevant authority?
Because there's a next section that gives the minister the power to grant certain licenses.
The manufacturer's licenses, etc.
Yes.
Okay. I find it a little confusing when we use relevant authority, but I'll hold on that point for now. But what you're saying to me then is that at the time of the grant, the board grants the license. The board is acting ultra-virus in granting the license. So at what point are you accessing 85D, and who is then going to be doing that? That would have to be the minister, isn't it? So the board in March of 22 grants me a license. You, CEO, FLA, administrative team, know that the license is granted outside of what ought to happen. I'm not understanding how this clause is going to be used.
Good. All right, let me explain. Let me use the current situation as it exists. So there are many persons who were granted licenses, as I said, contrary to the law. The Attorney General's opinion is that they are ultra-virus. The board had no power to grant such licenses. But what is the fix? How do you cancel, revoke those licenses, given that the legislation currently provides for set prescription as to the revocation of licenses? So, although the FG's opinion in law is that they're ultra-virus, how do you bring back those licenses into the within the scope of the law without a provision? And where you do so, the person would have a right to appeal. In one case, the person says, but you knew that I was a criminal before and you gave me the license. And the argument in court that the person advances that the board gave me the license, notwithstanding it's contrary to law, there's no provision to take it back.
But in this new bill, because you see, I hear you're responding to what currently exists. I can't see you with that glasses. I have to put on the other one. But in this bill, we have very specific provisions in terms of the terms and conditions that must be met to grant the license in the first place. So if we have that in this bill, why are we also including in this bill a provision that says you're going to, you may cancel the firearm authorization? I'm trying to understand from an operational point of view how this is supposed to work, because in my mind, if you have a board who is granting a license that ought not to be granted, where is everybody else at the FLA? Sleeping? And if they are not sleeping, why are they not saying, hey board, you're out of order, and ensuring that the right steps are taken against those board members who are doing that nonsense? I just don't understand. We don't need a provision like this. We need civil servants to act. That's what we need.
Member, let me explain. The civil servants report to the board, and the board has the power to fire the civil servants, Madam Member. And therefore,
but Mr. Daly, that's why you have a minister. And that's why the minister have a boss called the Prime Minister.
And it would require the civil servant to overstep his bound to go to the minister and the Prime Minister.
Oh, sir, it would require the civil servant to do his public duty. And it is because we shirk some of these public duties sometimes why we have some of the slippages we have in the public system. Because if you have a board that is not acting as a board should act, you have a duty to go to the person who has appointed the board and say, look, boss, the people who you put here to run this thing not doing it right. And I have a duty to tell you I can't be compliant with something that is outside of the scope of a board, because you are then being compliant with the wrong. Why is that just not a clear, understandable thing?
Because when I exposed it, I was asked to resign.
So what?
But that
take
would
it
have
to
been a
the minister,
consequence.
and if the minister act funny, take it to the prime minister. And that's why we have a media who's supposed to look and examine these things. So what if you're asked to resign? Anybody can tell you anything. They have to be right, though, right? They have to be in the right. Can't afraid of resignation, you know. You have to stand up for what is right.
Madam Chair, I too have a little problem with that 85(1)(d). It seems to me that the scheme of this whole section that deals with suspension, revocation, and cancellation is that revocation deals with the sort of circumstances where the person is unsuitable, whether recently discovered or they became unsuitable subsequent to getting the license. Cancellation seems more a type of administrative, non-controversial
is
section.
Without prejudice to the holder,
right,
as is stated there.
Right. It seems to be sort of uncontroversial.
So it's kind of a process to correct errors.
Right. So on the request of the holder and the death of the holder, where there's any amendment to discover some misspelling of the name or wrong date of birth or something like that. But when you come to D, it would seem to me that that set of circumstances would more properly belong in 84, which deals with a revocation. Cancellation is sort of, you know, as I said, not...
I'm kind of thinking whether, having heard Mr. Dallin, whether the mischief that is to be captured is that if an authorization is granted contrary to the provisions of the Act, then it's to be regarded as invalid. Really. And then, yes, I think that is it. That is what is it's directing at. And then the other question is that such an authorization, and where that law is breached in the grant of the authorization, then an investigation is to be done, which is a point, Member Golding.
I go further, Madam Chair.
And
there must be an offense if there is a board that is granting firearm authorizations contrary to law. There must be an offense.
And I'm going to tell you something why I am inclined to agree with that, but we'll have to put it forward for policy consideration, because we do have before the Parliament now matters in a report to the Parliament of irregularities by a board. And there is nothing to say that such a situation may not recur in the future. The truth is that
and Madam Chair, may I just underscore the
point?
point?
I share your view totally that we must be decisive in taking actions where either powers are exercised corruptly or ineptly. If you want to hold certain functions, you better go learn what is required for you to discharge those functions in accordance with the law. We can't be setting new standards, and at the same time we're setting it, we're going to normalize old practices that have not served us well. So, it appears to be an agreement among the committee that this clause is of concern. And if the intent is to address the validity of authorizations granted in breach of the law, then a better way to provide for it is to make those authorizations invalid. No, and also to consider making it an offense for anyone who grants it. So it means that since the board grants it, would be every single member of the board.
Can I ask a question, though, in relation to the question Member Bunting raised about the cancelling? Because the 85(1) chapeau says the relevant authority may, without prejudice to the holder. What do we really mean by without prejudice to the holder?
You can apply again.
At D. Yeah, but if the holder's license is being cancelled because the holder should not have been granted a firearm license in the first place, why is it without prejudice?
Which is why I said it belongs in the previous section.
So yeah. Hold on. So the only instance that I could see where that makes sense is where the grant should have taken place with the approval of the minister. in, for example, the manufacturer's license. We have cabinet provided there, but we have discussed that at length at 58B, so that it would have gone ahead without a compliance with one of the procedural steps.
But Madam Chairman,
I'm just saying, when you look at
85(1)(d) does not have to always and in all circumstances contemplate there being something effectually wrong with the person who's seeking the authorization. Right. It could be circumstances where there is an issue arising from something done by the board or procedurally, and it may not always be something that rises to the level of an offense either. All right, so I think we have to contemplate the wide range of issues and array of things that can be considered under D. I appreciate the concern and agree that there may be very well need somewhere in the Act to address the issues relating to matters regarding the efficacy of deliberation by board, relating to procedures by members working, employed to FLA or working or employed to, whatever it is that's connected to the considerations. But in this situation where you speak of it and listen to it, in the case of an authorization that may be granted under Section 58, if the holder thereof was granted that authorization contrary to conditions, may not always mean, I think, Chairman, that it is something that is specifically criminally offensive or related to the holder. That's just my 2 pence. Perhaps, Mr. Darling, you can explain what the intent was.
What you're saying takes away from the earlier point. And
I'm agreeing with the point. Right. I'm agreeing with what Member Golding
but you've gone
has
beyond,
posited.
yes.
I'm just suggesting that in terms of the legal drafting, right? Remember that our responsibility is really to draft in such a way that we're contemplating as much as possible the wide array of issues that can be considered. And I believe when you look on Section 58, in the context of 85(1)(d), it may very well include, and I stand corrected, but it may very well include matters that do not arise to the level of criminal offense. But somebody over there can explain.
Before that explanation, Madam Chair, can I ask, is in response to Member Charles's intervention, would it be prudent or ought we to consider disaggregating authorizations for the manufacturer's license, etc., different from the firearm license holder and the user's permit and so on, so on?
We did say we were going to do that earlier.
We did. Okay, thank you.
The bigger point was made to look at that particular form of authorization, and then it would be looked at across the spectrum.
Madam
right.
Chair. Madam Chair? Yes.
Mr. Dallin?
The cancellation of the license would be necessary in the circumstances mentioned by Member Charles. Even if the license is deemed invalid, you still have to do something with it. You have to cancel it or something. So something has to be done as it relates to the license. The license would be deemed invalid, but what action is taken as it relates to the existence of something that still exists in the system? So making it invalid would still trigger it being cancelled or something, Madam Chair.
So agreed. The nullity should have some, there should be some mechanism to address circumstances where it is deemed null and void. But you can't get away from the point that has been made, that where you are assessing the circumstance and it arises that perhaps the reason should require investigation, perhaps a criminal offense to be laid and holding persons responsible, that is something which we have to contemplate here. If it is not here, then we need to see how we can ensure that it is introduced here, because that really and truly goes to the gravamen of why we are here, and to the requirement a responsibility that we have to ensure that this product addresses the long-standing issues that we've had over time. So it's, again, what I'm saying is not in any way to be seen as offensive to what has been proposed, because that's a proposition that I agree with. I'm just suggesting that the clause as defined is a little wider than just criminal offenses.
Yet for the record, Madam Chair, it must be stated that the FLA did recommend the criminalization, as Member Golden pointed out, for persons who participate in this act.
Because our challenge...
All right, we completed the reading of that clause, 85? All right, let's just complete reading 85, and then we're going to take the lunch break.
2, the relevant authority shall, where it intends pursuant to subsection 1B, C, D, or E, to cancel a firearm authorization, in writing notify the holder of the firearm authorization, or in the case of a deceased holder, the legal personal representative of the deceased holder. 3, in the circumstances referred to in subsection 1C, the relevant authority may, where it considers it appropriate to do so, issue to the holder a new firearms authorization.
It may be a convenient time to take the break, and we can ruminate on some of the issues
Madam
in
Chairman,
relation to the power to cancel.
Since there's no provision for my dietary requirements downstairs, I may not rejoin you, but
You really want to deprive the committee of all that you bring, Member Bunton?
But in view
You're
of...
getting jealous?
In view of your earlier notice that there is going to be some policy reconsideration with regard to the role of the minister in the appeal, etc., might it be better to defer consideration of Part 6 until that, which is 4 pages, until that position can be communicated by the substantive chairman?
Come back after lunch and I'll respond.
No.
We're going to take the break. We're going to take the break to resume at 5.
I see you really desire my company, you know. I see you really desire my company.